classrooms operated by Volusia County School Districts in their pre-K ESE program that are blended with Head Start services are subject to child care licensing under child care facility standards under 402-302. Our argument is that under this particular statute that there is an exemption that applies to public schools. The public school exemption requires that it be an integral program of the public school, and then it also refers you to some exceptions under 402-3025, in which case we still believe an exemption applies, specifically with programs regarding children ages 3 to 5, when those programs are operated and staffed directly by the school board, and they're designed to meet age-appropriate standards under the guidelines set by the Department of Education.
So integral is not defined in the statute. What source do you contend that we should go to bring a definition to that?
Well, I would direct you to the testimony offered by two of the witnesses. Both are employees of the school board, and they have defined the program as not only essential, but necessary to the school board's obligation to meet learning objectives for students with disabilities under the Individuals with Disabilities Education Act, IDEA, and Performance Indicator 6 set by the State Board of Education. In addition, the school board itself, as an elected body of individuals charged for offering a free and public education in Volusia County, made that determination when they approved the cooperative agreement between the district and Mid-Florida. And in that agreement itself, they may render a determination that this is an integral program to their services in meeting the needs of students with learning disabilities that are in the age group of 3 to 5.
Do we even need to get into whether it's integral or not? I mean, I'm looking at the way the statute's structured, and you have the 402-3025 that I know you say applies, and it talks about age-appropriate standards and children 3 to 5. I assume there's no dispute that all the children involved here are 3 to 5, and I'm not sure there's a dispute about age-appropriate standards, but assuming that there isn't, then it is either the case that the programs are operated and staffed directly by the schools, or they're not operated and staffed directly by the schools, and depending on which of those it is, it goes to which of these subsections, and then it seems like the case would be resolved without ever having to worry about whether something is integral or not integral. Is that, help me understand why that's not.
That is correct. Based on the testimony in the record and the brief provided by the department, I do not believe any issue has been raised that these classrooms aren't designed to meet age-appropriate standards as set by the Department of Education. So I think that there's agreement as to that particular element. Where we do disagree has to do with specifically what is the term operated and staffed directly by the schools mean under the statute. And if I may, by way of example, I believe that there is agreement that in those districts where the school district is of itself a Head Start provider, a provider of Head Start programs, and have blended classrooms, should that be the case. We are not aware of any other classrooms of this blended nature. But if the Head Start provider were in fact the school district in that particular district, this would not be an issue. It would apply to the exemption because they are the sole and only participant in the blended classroom model. On the other hand, you have an example like Mid-Florida, who is a provider of Head Start programs in 18 other locations in 3 counties, where they own and operate and staff the Head Start classrooms, independent of any involvement with the school district. In those, I believe we would both agree that Mid-Florida is subject to licensure as a child care facility. Where the disagreement comes in is this particular blended classroom. To kind of set the perspective on why the blended classroom is different than either of the other 2 models discussed, is that this is a program the Volusia County Schools started in order to meet the needs of students with learning disabilities age 3 to 5. Keep in mind, kindergarten generally starts at age 5, so the school system doesn't have readily accessed population of 3 and 4-year-olds. So when the standards came down, they started to explore blended classrooms. They started with employee blended, meaning they surveyed the employees in a particular elementary school to identify if there were children of those employees that met the criteria for the typically developing peers to be provided in a classroom to serve the students with learning disabilities to create the inclusive classroom. When that population was met, they exhausted all resources in that population, they added another element to their blended classrooms, which included community. That's either through private pay or through VPK, voluntary pre-K vouchers. To again, add in the typically developing peer for the students with disabilities to create the inclusive classroom. When they exhausted that population, the next avenue of exploration was to look at who is the Head Start provider in Volusia County. That is Mid-Florida. They are the only provider of Head Start services in the Volusia County School District. And the sole purpose in that mechanism was to create another pool of population of typically developing peers of 3 and 4-year-olds to supplement the pre-K blended ESE to create the necessary inclusive classroom, establishing the least restrictive learning environment. So in that context, that's where Mid-Florida was asked to collaborate with the school system. But case in point, as of last week, the school district notified Mid-Florida one classroom at the Horizon Elementary School will be going away this fall because there is sufficient population of employee blended at a neighboring school that they can open up another blended classroom of the employee population. So whether these classrooms come and go is entirely dependent on the school district and whether or not they have defined a particular need for those services.
I'm going to follow up on Judge Windsor's question because I may have missed the answer. So let me reframe it. Do we have to pass on whether or not this is an integral program if we conclude that the exception in 402.3025.2 applies? That is, that Volusia County Schools operates and staff, or the program is operated and staffed by Volusia County Schools.
I don't think you can pass on that issue because it is contained in the express definition of child care facility as an exception. So under 402.302.
I'm sorry, not to interrupt, but you don't think we can pass on which issue?
The integral.
We
Because-
cannot pass on integral.
Right, under 402.302, under the definition of child care facility, the exception is for public and non-public schools and their integral programs. So if you can't meet that standard to get you to 402.3025, which further creates some nuances for 3 and 4-year-olds versus public schools and non-public schools. So I think it is an initial prong to determine whether or not 402.3025 applies.
I'm sorry, maybe I'm not following. The integral or not integral is the first prong?
Yes, Your Honor.
Okay, but the statute says public and non-public schools in their integral programs except as provided in 3025.
That is correct. That is correct. And so when you get to 402.3025, under the first subsection, it specifically excludes from the definition of child care, which is a different definitional term in 402.302, the 3 to 4-year-old classrooms that are operated by the district.
Right, and so I guess I just want to make sure I understand your position then is if we hold that these programs are not directly staffed by the school, then you lose and it doesn't matter how integral or non-integral these programs might have been. Am I capturing that right?
Well, I think we went under either analysis. If it's deemed an integral program of the school board, it is exempt from the definition. And then there are exceptions, and so you have to rule out the exceptions. So when you go to the section that identifies the specific exceptions, the definition of child care excludes these particular programs. And so it's kind of...
But then B brings them back in. It says, you are child care and shall be subject to licensure, paraphrasing, if it's a program for children under 5 when the programs are not staffed directly by the schools.
That is
Wouldn't
correct.
that trump everything under sort of the more specific controlling?
Yes.
Okay, so if we found that the program was not, and I'm not saying we will, and I understand you argue that it is directly staffed, but if, as a matter of sort of the statutory logic, if this court concluded that these programs were not staffed directly by the schools, then we would be obligated to rule against you. Is that right?
We would certainly concede that we would be subject to licensure as a child care
Okay.
facility if it is deemed that we don't fall within the context of the statute.
Irrespective of what we thought about your
Whether it's
arguments about
integral or not. Yes, sir.
Okay, I just wanted to make
So
sure.
then let me ask, I guess, the converse. If we find that the program is operated and staffed, do we also need to make a determination as to whether it is integral?
If you find that the program is operated and staffed directly by the school, it is excluded from the definition of child care and then would not be subject to the child care licensing facility. So you would not have to make a determination that it is integral.
So either way, we can set aside this issue of whether it's integral or not.
In either case, yes. With
That's
regards,
assuming, I guess, and I will ask your opposing counsel about this, but the other sort of qualifiers in 1A2 about age-appropriate standards, which I guess would.
That is one of the items that would have to be met. And as I indicated, I don't think either party has raised that as a point of contention as to the nature of these classrooms. But there is testimony in the record from both the ESE director and coordinator for the school district to indicate that these classrooms do achieve age-appropriate standards under the Department of Education's requirements. As to the critical issue, which is operating a staff directly, there is testimony on behalf of the department that they have applied that statute to mean solely by the school district, which would be the one model that I had talked about if the school district were in fact the Head Start provider. On the other hand, this classroom is owned, the facilities are owned by the school board, staff is provided by the school board. The typically developing peers are not, but the students that have disabilities that need to be served are students of the school board and qualify for FTE funding. And but for those students in that classroom, Mid-Florida would not be in this environment. The department likes to argue or ignore all of those facts and say this is just another Head Start classroom that Mid-Florida is operating, and it just happens to be in the same spot as the school district. But in any policy conflicts that occur, the school board has the final say as to whether or not Mid-Florida's policies are followed or not. Where there has been challenges, they have developed an implementation guide to clear up operational challenges that happen as a fundamental nature of the blended aspect of the classroom. But at the end of the day, it is the school board that controls and owns the facilities, whether the classroom happens, the curriculum, the standards, which ESE students are assigned, how those students are served, what their individual education plans require. Mid-Florida is simply providing the typically developing peers, just as if employees did or the community did, and they are simply providing Head Start services to all 18 students who are all dually enrolled in the Head Start program, whether they are an ESE student or not.
Let me push on that just a little bit.
Yes, sir.
It does strike me that there is sort of a commonality or a common mission, and the school board sort of takes the lead and has control over that. At the same time, it seems like in this cooperation agreement, they sort of go out of their way to construct this Chinese wall where certain teachers are in charge of certain kids and Mid-Florida is in charge of their kids, and there's arguably there not a lot of commingling, if you will, I guess.
So I would respectfully disagree in the practicality of how the program is operated. Yes, the school district's employees are responsible for ensuring that the ES students are achieving the requirements under the IEP, their individual education plan. That is no different than if that 3-year-old were placed in another Head Start facility that had an IEP somewhere else. The school board would still retain responsibility for ensuring those IEP elements are met. Mid-Florida's teachers in that classroom are responsible for ensuring that the Head Start program standards are being met. But as to the responsibility for the students, all 4 staff and personnel in the classroom have equal responsibility for the safety and welfare and education through their co-teaching and supervision model as that program is currently structured. So the cooperative agreement does a couple of things, and that is Mid-Florida does participate with the school board in their child find to find students with learning disabilities to get them into a pre-K program, whether they be in the ESE blended or in their Head Start program elsewhere. So the cooperative agreement does address other issues beyond these specific blended classrooms. And if there are no further questions, I'll reserve the balance of my time. Thank you.
Thank you.
Good morning. May it please the court. Stephanie Camfield, Assistant General Counsel for the Florida Department of Children and Families. The thing being forgotten here is that we have 2 classes of kids in this classroom. You have Volusia County students who are ESE receiving students, and you have Head Start only students who are procured by Mid-Florida to be utilized in the classroom, much in the same way a textbook or art kit would be utilized by the ESE students. That is the concern that the department has in this situation. Volusia County Schools and Mid-Florida have both gone to great lengths in both their cooperative agreement and their implementation guide to clarify that there is a difference between the way these kids are treated in the classroom and who is ultimately responsible for their care. The Mid-Florida agreement points out that these kids do not get a meal unless there's an agreement between Mid-Florida and Volusia County Schools. The children do not get transportation to and from the program except as agreed upon between Mid-Florida and Volusia County Schools, among other things. If you look at the cooperative agreement, you look at the implementation guide, you see that these kids are treated differently. And the concern there is who is overseeing how those kids are being treated and
So
whether that's being
help us
appropriately done.
visualize this. In a classroom, are these kids segregated to one corner and taught by one teacher, and then the other kids are segregated in another corner and taught by the Mid-Florida teacher? Or are they more integrated?
The way that the testimony came out is that they're folded in because it's supposed to be the kids in an environment where both are interacting with each other. The concerns are the practicalities of that, and that and you pointed out the age-appropriate practices point. The age-appropriate practices that were brought into the record and testified in the hearing were specific to the ESC students only. They were not in regards to the Head Start children. And if you look at the practices, you look at the evidence that was entered onto the record, it only applies to ESC students who have an IEP. It does not apply to the 3 and 4-year-olds that are enrolled as Head Start only kids in the classroom.
But the statute's talking about a program that has age-appropriate standards. I mean, there's one program here, right, that we're talking about? Or is your argument that these are
There
two
is-
independent programs operated kind of in
The-
one room?
The program they call it a blended program, and the way that works is that you have two sets of kids. You have the ESC kids who have an IEP.
I get that, there's two
Okay.
different, and the whole educational benefit is that they each kind of benefit from being with the other as opposed to being without the other.
Well,
Particularly.
the
as to-
ESC children benefit by having the Head Start only children there. There's no guarantees or anything laid out as to what the benefits are for the typically developing peers who are just Head Start only children. And if you look at the agreements between the two, they're clearly treated differently as far as who's ultimately responsible for those Head Start children. Mid-Florida has pointed out that we do license their programs outside of the school. We do not license the Head Start programs that are operated solely by the school. So if
Because of these statutory exceptions.
Correct, because of these statutory exemptions. In this particular instance, you now have an agreement between Volusia County Schools and Mid-Florida that seeks to create this agreement whereby you have kids who are in this program who are not students and do not enjoy the protections of being a Volusia County School student, but yet they're in this classroom and being serviced by Mid-Florida for Head Start services. Whatever that means for those kids, they're kind of being used as a means to an end in order for them to operate this ESC program.
Yeah, but whatever's behind it, once they get there and once they're in the classroom, there is one joint program being operated, right? And the issue is what do we make of these sort of staffing divisions and how does that fit in with the statute? I mean, there's not an argument, as I understand it, and correct me if I'm wrong, that Volusia County is not operating some sort of program with respect to that captures this.
We don't have a problem with the program for the ESC students. It's the inclusion of non-ESC students who are not even students at all and don't enjoy the protections and insurances that come with being a student enrolled in that school.
Okay. So the discussion we had with your opposing counsel about how we sort of walk through the statute, do you agree that the question in this case is this operated and staffed directly by language as opposed to integral? In other words, we can resolve the case under either 402, 3025, 1A or B?
Integral is not offered a definition, so it is still the first prong. You are to look and see, is it integral to the school? Mid-Florida and the school district both state that it is. So we went ahead and went to the next level step, which is, are there age-appropriate standards in place, and is it operated and staffed directly by the schools?
And is there a factual dispute in front of us about, I'm sure there's not about age 3 to 5, right?
I'm not aware of any.
Okay, and then on the age-appropriate standards?
The age-appropriate standards there is. Throughout the record, you'll see that there were arguments that the non-ESC Head Start only children, that there were no practices and standards in place specific to them. All the practices and standards in place were in regards to the ESC students. And if you look at the recommended order, specifically paragraph 15, the only finding that the ALJ made was in regards to age-appropriate practices and standards for the ESC students under their IEP.
Ms. Campbell, help me with this, because it seems like the argument can be made that while different teachers have task-specific assignments, the school board has brought this program in under their umbrella. They're pursuant to some mandate to mainstream these kids, and they ultimately bear the responsibility for the outcome or the success or failure of the program. Is that a fair statement? Or
In regards to the ESC students, yes, but in regards to the Head Start only students, the cooperative agreement and the implementation guide clearly delineate that these kids are treated differently. Maybe not in the sense of instructional one-on-one, but in the way that they receive meals, transportation, and their Head Start services, which are run completely by Mid-Florida. And going further than that, Volusia County Schools can even discount their Head Start services when they're in this classroom, so that's
Is it
even more of a
possible
concern.
that this statute just never contemplated what we have, the creature that we have today, the blended classroom? And if that's the case, then we look at the text of the test that I think is governing operating and staffed directly by the school. I mean, we certainly have that, at least for a certain population of the students, correct?
Well, the blended classrooms, the way that this is operated typically in other parts of the state is that the school itself is the Head Start offer. They offer Head Start directly. They don't bargain, they don't have a third party come in and contractually provide those services. So that's kind of the little snafu in this particular situation, is that they are contracting with a third party to procure children for a program. So it's really a twofold thing. Mid-Florida is contracting with the school to provide Head Start services for the ESC children. That's facet number one. Facet number two is, in this particular instance, they've also contracted to procure Head Start only children from their program, which otherwise is licensed, in order to be integrated into this classroom as, I hate to say playthings, but I mean, they're in there to be integrated with the ESC students as typically developing peers so that these kids the ESC children can learn, I guess, appropriate and age-appropriate things.
Right, but I mean, as a consequence, however they got there, as a consequence of that, you wind up with this arrangement where Volusia County staff members are providing educational services. I mean, they're leading the classroom in some instances. Everyone's sort of partnering together, and so they're working with these kids. It seems like it would be a program that they're staffing, at least in part. And so then I guess it goes back to your argument, is that the whole program has to be, operated exclusively, I guess, by staff.
Well, directly means with no one or nothing in between, and we do have someone and something in between. We have Mid-Florida,
Well,
and
not
we
in
have an
between,
agreement.
but alongside them, more than between, right? Because they're both working with every child in that classroom. I mean, that's my understanding of the
They are
record, is
working,
that-
the Head Start program is working with both sets of kids, but
talking about
there's
the
nothing
human-
about the Volusia County teachers as to whether they are in fact teaching or interacting with the Head Start only kids.
I thought the kids were all integrated together. So, I mean, a teacher, back to Judge Ray's question, that the Volusia County employee teacher is not just speaking to the Volusia County enrolled students, right?
They're not, but there are standards and things that they have to meet in regards to the ESC students
Sure.
that they do not owe the same duty to the Head Start only children.
But they have mutual duties, though, as well. The Volusia County teachers that are teaching this blended population, they have mission, they have operational goals that apply to both sets of students, correct?
I do not agree. The department's position is that they do not. If you look at the cooperative agreement and the implementation guide, it's clear that all the duties flow from Volusia County to their ESC students and none to the others.
And none of them overlap between the mission and the goals of what the Volusia County school teachers are tasked to accomplish. They don't overlap at all with the goals of the other teachers? The
In
Mid-Florida
regards to the
teachers?
Head Start only children that are not enrolled students in Volusia County schools, no.
Okay. Well, we'll
But
ask
yeah,
that as well.
the contractual arrangement, though, requires the county teachers to work at some level with all the children in that classroom, doesn't it?
It doesn't require them to work with the Head Start only children. It requires the Mid-Florida folks to work with those Head Start only children.
We'll take a look, I guess, but that was not my understanding of the agreement, but.
Do the, I guess the visiting teachers or the Head Start teachers, do they benefit from some of the perks that school board employees would? I mean, do they get meals or parking or, that's once they
I don't
come
think
in?
that I don't think that the personnel stuff came up during the hearing. If you look at the record, it only came to whether the children received.
Yeah, I mean,
the
it just seems to
Head
me
Start
when
only
you're
children
talking about
received
staffing directly and you bring somebody in under your umbrella, for example, I was invited to appear here today and sit on the bench, and I was provided parking and a room to change and a visiting office and all these things, and so I'm kind of under this umbrella here for the day and enjoying some of the perks and the benefits of general employment. It just struck me, I wonder if these teachers who are brought in and arguably made an integral part of the program, if they enjoy the benefits, or if the school board has liability for these people. If there's some adverse event and a lawsuit, is the school board on the hook? Are they staff and they're responsible for the people they bring in?
And I think if you look at those agreements, I think that that's what really is underlying all these agreements, is who is going to be liable if one of these non-students is injured on site or as a result of some action or inaction on behalf of Volusia County or the Miss
Does it
Florida
speak to
folks.
that? I couldn't remember if it,
It kind of it dances around it, and that's the concern that the department has with those two agreements, is that we have conflicting statements on the record as to who's responsible if a child wanders off from the facility or doesn't get picked up or anything or doesn't get a meal, who is ultimately responsible. And when you come back to it, these two parties have at least two, if not three things on the record that delineate who is ultimately responsible for these kids. And in multiple instances, it is that Mid-Florida is responsible for the non-ESC Head Start only kids.
But I'm not sure that answers the question as to whether it's directly or jointly staffed. I mean, in a regular classroom, if you have a teacher and a teacher's aide, it would be easy to say that the teacher has the ultimate responsibility in terms of someone missing their coat or wandering off. But that wouldn't say that, you wouldn't then say that it's not jointly handled by the teacher and the teacher's aide. I mean, everyone's sort of,
But both would be school district employees
Right,
in
but
the
I'm saying-
school with students in the classroom.
I agree,
so-
but my point is that the issue of who would be liable in certain hypothetical circumstances, I don't think necessarily gets to the statutory issue here, which is whether these programs are, whatever the statute says, directly staffed by the school.
And that is the crux of it, is what does directly mean?
Right. Okay.
So the department would ask that you affirm the final order as issued, or otherwise, if there are continuing issues of fact that need to be determined, that it be remanded back to the administrative law judge for further action.
okay, thank you.
May I please the court to address a couple of things. As to our staff afforded any opportunities that other teachers would, in fact, they are invited to participate in school training, but more importantly, they are subject to school board standards when it comes to screening to allow for them into the classroom. In addition, there's testimony in the record where the school board reserves the final say on whether or not a particular teacher stays in the classroom. If there are different disruptions between lack of cohesion in the co-teaching model, the school district does have the authority to dictate to Mid-Florida reassign or to remove this person from that classroom, not necessarily because of a health, safety, welfare, but simply because of incompatibility with the classroom. As to the
That's
education.
probably true of volunteers and everything else, though, isn't it? I mean, every volunteers have to have background checks, and I'm
Absolutely.
sure it can be removed if they're acting inconsistently with.
Absolutely, and is the principal at this particular school site who has that say at any given day. In addition, there in the implementation guide, it does outline that the school district discipline policy does apply it usurps or supersedes what Mid-Florida's disciplinary policy is. As to the age-appropriate standards, you do have testimony from two school employees that say the curriculum that they have adopted was adopted on behalf of the school board based on the school board's selection, and Mid-Florida had to concede to using that curriculum to achieve Head Start standards. And the curriculum that is in place by the school board does meet age-appropriate standards, and you'll find that in both Ms. Gillian and Ms. Kelly's testimony. As to the classroom itself, the department would have you believe the children show up and are sort of distinctly different, as if one were wearing a red shirt and one were wearing a blue shirt. That is not how these classrooms function. They are commingled, they are interjected. It is a co-teaching blended model. It is important to note that the 8 ESE students in any particular classroom are dually enrolled Head Start students. So all 18 students in the classroom participate in Head Start program services, the behavioral health, the family support, the advocacy, the medical support that they get. The school board wanted that as additional supplemental services for this target population. And so while the school board may be responsible for the learning objectives under the IEP for those 8 students, all the staff in the classroom are responsible for implementing the curriculum in a co-teaching model basis
But
to
the
all
opposite
the
of what
students.
the opposite of what you said earlier is not true, right? The Head Start students are not enrolled in the district, or are they?
So all 18 students are enrolled in the Head Start program. Of those 18, Generally, 8 of them are ESE students with an IEP, which was the basis for the classroom to begin
And
with.
the remaining 10 are not Volusia County enrolled students.
So they are not enrolled in the context of eligible for full-time equivalent funding under the state funding matrix, but they are for purposes of headcount or attendance, but they do not generate the financial matrix for full-time equivalent
Is that all
funding.
laid out in the agreement as well?
That's laid out in the agreement as well, and I am over time, so.
Yes, thank you. Thank you to both counsel.
David.
This concludes the panel's cases today. We are adjourned. Thank you.
All rise.